what the Church of Scientology is so afraid of.
This is SPTV.
Welcome back, everybody. Aaron is here with some SPTV and one of my favorite guests, attorney Zach Morgan. How's it going, Zach?
I'm good, Aaron. I'm glad we got to do this. You and I had talked about sort of doing this as I will watch all your videos. Obviously, I'm not there in California with you. I'm at my regular day job, but being able to follow along with you, questions pop up. I see the chat. We have a lot of questions. And one of the things that you had mentioned in some of your commentary today was there was the big question that was asked prior to the lunch break. And then for reasons beyond the court's control, there was this other case that came in and the DA sort of never really followed up. We never got an answer to that question. And I don't remember exactly what that was, but I wanted to discuss the significance of that question, why it matters to and specifically why it matters to the jurors on the facts of this case.
Totally. Okay, so let me pull up the notes and we'll go back to it. Because this is something where actually I'll give the question and I'll give the answer. Jane Doe 1 did answer the question. She was in the process of answering the question. She was almost halfway through the question, and there was a lot of meat on that bone that didn't, I don't know how to proceed with that analogy. Didn't have a chance to get eaten. Wasn't digested. I don't know where to go with it. But okay, so here's what it was. It was the question that was posed to Jane Doe 3 by Deputy DA Mueller had to do with at what point did you decide, okay, I'm actually going to end the relationship? And she answered that question. And then, well, here's what it is. She was put onto an ethics program when she complained to the ethics officer at Celebrity Center about Danny having assaulted her. And Deputy DA Mueller said, what is involved in the ethics program? And she goes, she had me reading some things out of the ethics book and some policies. She had me read that Scientologists can't report each other to the civil authorities like the police, and read that I cannot tell anyone what he did to me because he's a celebrity. And she is the ethics officer. She also showed me a policy called ethics protection, that if you're an upstat, if you get a report, like if ethics receives a report on someone who's an upstat, you file the report with a yawn and you investigate the person who submitted the report. And she also showed me the high crimes policy, and that it would be an offense to report him. In other words, a high crime to report him. And she asked me to demonstrate it with a demo kit to show that I understood what I was reading. She says, you have to fully know what it says and you have to do everything it says. I got a pass while doing the demo. Yeah, so this is the part that didn't, a non-Scientologist wouldn't really know what she meant. I got a pass because getting a pass means something different in the real world than it means in Scientology. Okay. I got a pass while doing the demo of what would happen if I told other Scientologists Danny had raped me. And I had to read that handling for a suppressive person is fair game where you destroy the person. So I understood and I got a pass. And then the judge says, we're breaking for lunch.
Right.
And it was never revisited. She never had a chance to explain what everything she just said actually meant.
Yeah, so the DA has some work to do, and obviously I have all the faith in the world that the DA's case is prepared. They certainly wouldn't be trying it if it weren't ready. You have to follow up with that question along the lines of, okay, I know what that means in the outside world, but what does that mean in the world of Scientology, and why does it mean that, right? Yeah. Why does it mean, so the first question is, what does that mean? And she's going to explain it, because words that are not used in the normal lexicological context, a big word there, in the normal use of the way we use and define words, if it's outside that normal understanding, it needs to be defined, because the jury will assume reasonably they know what this word means. If the word doesn't mean what you think it means, then it needs a definition to put it into context, because the judge has made some, as you've identified, some pretty key rulings about the role in a traditional religion such as Christianity or Judaism or something along those lines, what we would call the doctrine or the dogma of the faith. And so Scientology there's not a direct correlation, but essentially what do the words and the terms mean in this context, so that the jury has a frame of reference to refer to it from.
Yeah. Well, what's interesting is that the DA actually was quite thorough in every other instance of testimony throughout today, every time she mentioned a Scientology word or a phrase or something the ethics officer said or Danny said or the chaplain said, the DA did say, did you understand what they meant by that? And then she would say what she understood. And then she would go, was that something you were told that's what it meant? Or did you understood that's what it meant from your own study of Scientology?
Right.
And then she would answer that question. And then he would say,
now let me stop you right there. That sentence that you just said, was that from your own study of Scientology or were you told that? That's key. Yeah. And the reason that question is key is because if at some point, and I know you alluded to the fact that some of these internal Scientology documents were shown in the opening slideshow, the PowerPoint presentation in the opening statements portion. In order for that to come in, the document itself is generally not admissible if it's hearsay. And so we've talked about this in a prior video. If she got that information because she was told that information, that statement is hearsay, but you can get around it because it's not offered as true. I'm not stating that the information I was given is accurate. I'm telling you I relied upon that information. It's not for me to say whether it's true or not, but rather that I relied on it. So the statement that would otherwise be hearsay can come in, comma, if we lay the foundation by this witness saying, I relied on that. I don't know whether it's true or not. I'm not L. Ron Hubbard. I didn't write this policy. And I didn't teach this policy to somebody else. This was what was told to me. I'm relying upon this information. So that's a key question that you should hear over and over and over again, because they're laying the foundation to get around the hearsay objection.
Right. And actually, that did come up a bunch of times. Sean Hawley, and Sean Hawley's the one who's doing all the objecting, not Philip Cohen. I actually got to sit next to Sean Hawley for about 45 minutes today.
So I will tell you, that means Sean Hawley will be doing the cross-examination, and you've already identified that. But under the court rules, the person who objects must be the person who also examines.
Oh, very interesting. Very interesting.
Even though they may not specifically say that Joe Blow is going to cross-examine Claire Headley or cross-examine the detective or cross-examine who's it's or what's it's or whatever, the person who is objecting must be the person who conducts the examination.
Yes. So sometimes this happened a bunch today. The DA will ask a question about what Jane Doe 3 thought or believed. And instead of Jane Doe 3 just answering, yes, I believed this, she would say, this is what Scientologists believe. Sean Hawley would say, I object. And the judge would say, rephrase or lay foundation or yep. What is lay the foundation, yeah. Establish foundation. Yeah. And then eventually, but sometimes the judge would go, she's not saying we're not accepting what she's saying because we're saying that's what Scientologists believe. We're saying that's what she believes Scientology believes. And it goes to her state of mind.
Yeah, it goes to the state of mind. And that is, it's not about what the church teaches, because that would be the truth of the statement, but rather the effect on the listener. It helps set the frame of mind. It provides context for the reasons that the Jane Doe acted or didn't act in a certain way, why she did or didn't do certain things. It provides a frame of reference and context. So now the jury can decide, were these actions or omissions reasonable or not reasonable?
Right. Here's what I want your opinion on, because clearly the direct examination goes on for hours and hours and hours. Clearly, the DA's got something in front of him, a framework, a chronology he's working through. There's no way he just lost his place. I feel like there was some decision probably made that we're going to move on from this point. I just don't believe it. He was just being absent-minded about it. So I want to ask you this, though. What would a prosecutor, how would he be processing the fact that when Jane Doe 3 talks about this issue, she gets very animated, angry, and upset? Is he possibly trying to avoid that, or would he want to lean into it?
Not necessarily avoid it. If done strategically, it can play well. Especially considering these Jane Does are exactly that. They're just average Joe citizens of the world who happen to be involved or have a past involvement with the Church of Scientology, as opposed to being a high-profile celebrity, specifically an actor. And the reason I say that is everybody watched the Johnny Depp Amber Heard trial because it's broadcast on all the media all over the world for free. You can watch it on YouTube, catch it on cable TV, whatever. The jury has said we didn't believe Amber Heard because she could turn the emotions on and off like a light switch, and she's a trained actress. This is what she does to pay her bills and feed her family. This average Jane Doe who is stoic about certain just statements of fact. Yes, here's how I got involved. Here's the people I know. But when you get into the meat of the details of the allegation, you would expect to see a flood of emotions coming back, especially when she has basically been told, I believe you, but it doesn't matter. Even if he did, even if we think he did what you say he did, it doesn't matter because he's a celebrity and you're not. Shut your mouth, go away. And now she gets the opportunity to tell her story. So if you strategically, that can be helpful. Now, it doesn't help you much if somebody just sits up there and is a puddle of tears for 3 days, although it may very well be reasonable to be that way. The jury just, you have kids. There's a point where you're like, all right, we got to move on, right? Like, I understand it's emotional. So you strategically, it can be done well. And I think Reinhold Mueller, to his credit, is probably finding this is the time I can lean into that. I would also, since it was a break for lunch, I would bet all the dollars in my pocket, of which there aren't many at the moment, but I would bet all the dollars in my pocket that he's meeting with this trial team and they're saying, hey, let's follow up on this. Or let's circle back to this thing, or we didn't flesh this out very well. Or, hey, we think they're going to cross-examine on this point. Let's shore this testimony up, or let's flesh this out a little bit further, knowing they can come back and tie that loop in later.
Oh, right. They don't have just one crack at this.
Right.
They're going to do direct, cross, redirect, recross.
Yeah.
Possibly.
Yeah, and so she's going to testify again tomorrow. So there's going to be more. I'm assuming they haven't rested on that witness, but there'll be more. There'll be more questions for her tomorrow. They may very well. I would be surprised if they didn't try and tie it up at some point, because Mueller's got his own notes. He's also got counsel at the table with him, who their only job is to play devil's advocate, right? To do opposition research. What if this question is asked? How can we explain this away? How can we shore this up? How can we provide context? And then at lunch, they say, hey, here's some weaknesses we've seen. We're going to have the afternoon. And he probably thought, I'm going to have several hours this afternoon. And in turn, he didn't really have that much time, right? He had, 30 minutes.
It's
right?
true.
Because court adjourns at 4.
It'd be so frustrating to be resuming proceedings and you have like 16 minutes before court's going to end.
Yeah. And so that becomes a strategic point, because the jury's going to go home or back to the hotel room. I don't know if they're sequestered or not, but they're going to go back. Okay. They're going to go back home and they're going to spend the evening, the night, and the next morning pondering about the last thing they heard before they left the courtroom, before the witness left the box. So you want to leave that jury with something to think about before they go home. So you can also strategically load that question and answer, then sit down and the judge says, see you tomorrow, and the jury gets to ruminate on it all night.
Yeah. Interesting. So, there's a difference between emotion, like, crying and being upset, and being angry. And what was notable about Jane Doe testifying about having to go through this process of demonstrating with physical pieces. This is a Scientology thing called using a demo kit. Demonstrating to the MAA to verify that she truly understood what would happen to her if she went to the police, what would happen to her if she told other Scientologists that Danny had attacked her, and what would happen if she was declared and treated as fair game by Scientology. She was getting angry, not grief is the word they use in Scientology. What's the word in the world if you're crying? Not just crying. Well, you're getting emotional.
Getting upset. Yeah, you're getting upset. You're getting emotional. You're having
but upset can be crying or it can be angry. She was getting angry. Is that something that would make the DA nervous? Is that emotion I just want your opinion.
Sure. So what makes an attorney nervous is when the affect doesn't fit the scenario. People giggling at a funeral, people crying sad tears at a wedding, and you're not the ex of one of the participants in the wedding, right? So when the affect or the behavior doesn't match the circumstance. In this case, I think the behavior, having not been there, but based on what you're telling me in my experience, the behavior matches the circumstance, right? I'm being told, we don't care if this bad thing happened to you or not. If you tell somebody, do you know what's going to happen to you? Show me what it looks like in this box of random crap, what it looks like to get thrown out of Scientology. Show me what it looks like in this box to be declared an SP and you get cut off from your family. I don't really care what happened to you that night or those series of nights or those series of events. You need to understand what happens if you go to the police. That is in my opinion, an absolutely reasonable response to that question, because what they said was, we don't care what happened. We care what happens to us, not you.
Right. By the way, we got 1,000 people watching right now. If you're watching live right now, do me a favor and hit that like button. It does seem that if you get a bunch of likes, YouTube will actually push out the notification to everyone who has asked for them, and YouTube decides not to send the notifications. Okay, I have to ask your opinion on something else. And,
Sure.
I hesitate to say things that sound like I'm criticizing the DA, because I'm a big fan of these guys. But what am I here for if not to offer opinions and feedback, right? What struck me was that the opening statements were like, I like to compare it to like a 5-hour James Cameron movie. The movie might be great, but it's too damn long.
Yeah.
Okay. Now I'm looking at, and again, I thought the opening statements, the information was very effective. I thought it was about twice as long as it needed to be. And so here's where I'm going with this. I just couldn't help but going, look, we're sitting here talking about, there's 3 charged victims, but he, in the opening statement, it included the story of Kathleen from Canada, who's going to be testifying. So you're talking about 4 women who were drugged and raped, and you're telling their stories. If people are falling asleep, I can't help but think you're doing something wrong. Like, you cannot possibly be telling the stories of 4 women who were drugged and raped and have people falling asleep and think, yeah, that's good.
It's, yeah, I don't disagree with the pretext. Of course, context matters. And fortunately, you were there to be able to provide some, because it's hard to speculate without having somebody there with firsthand knowledge, which you have, which is good. I don't immediately have an opinion on it, just because I've had opening statements that have gone 45 minutes. I've had opening statements that have gone 5 hours. Right.
Wow.
And inherently, I am a windy speaker, right? I tend to cut myself not enough time on my rebuttal close. Often when I'm on the top of the case as the plaintiff's lawyer or as the prosecuting attorney on a matter. But the opening statement, there's 2 approaches. There's this, here's what I'm going to show you. And I know you grew up in a cult and didn't go to public school very long, but right, the basis of writing an essay or telling a story, tell me what you're going to tell me, and then tell me what you told me.
Right.
But essentially, he's having to do that 4 times. But at the same time he's doing that, he's also trying to create a framework as to why does it matter the church's involvement, specifically with the victim who is in a long-term relationship with the defendant. Right. So I'm trying not to use his name because I don't know exactly how the algorithm works, and I don't want a bunch of sympathizers pouring into your comments.
You can say Danny Masterson.
Okay.
It's all right.
I wasn't exactly sure how the algorithm worked, but and so it's just one of those things that this is a complicated case from a technical perspective, not from a factual perspective. Perspective, there is a habit of behavior that's being posited by the state, being presented by the state. The steps are all the same. Come over, have a drink. I put something in your drink. You lose control, either consciousness completely, or at least become unable to communicate in a meaningful way. I take advantage of you. And then, right, sort of this rinse and repeat. The other thing to remember is the way California charged him is very similar to a RICO case. They need 3 of 4 convictions in order
they need 2 of 3. They need 2
or
of
sorry.
3.
Sorry. Yeah. Sorry. There's 4 Jane Does, only 3 of whom are presented as victims. They need 2 of 3 convictions in order for the outcome be Danny Masterson goes to prison.
Right.
And so they have to sort of lay that out to start with. Why does it matter? And so there's an hour and a half of speaking, just sort of laying out how I'm going to fit this case in this box of 3.
Right.
As opposed to trying these 3 cases separately that occurred 2.5 decades ago.
Yep. Makes sense. And to be fair, it wasn't just the prosecution that I thought was being long-winded. I think I tend to be harder on them because they're the ones I'm rooting for. I thought the defense was losing the jurors as well.
Yeah. When it's this technically complicated, not factually complicated, but technically complicated, it's really hard to have a good opening because your opening sets the road, because they're always going to resort back. The jurors will resort back and think, oh yeah, he mentioned this in his opening. Oh yeah, he mentioned this in his opening. And if they're seeing something for the first time, they're going to go, wait, what, why? We didn't know this was coming. They didn't tell us about this testimony. So in my opening statement, if I make a statement, you're going to hear from witness X. If I don't put on witness X, the jury doesn't tend to like that. But if I also say, if I don't say you're going to hear from witness X, and then witness X shows up, the jury's going to spend the first half of the examination not focusing on the question and answer. We're trying to figure out, who is this person? Why are they here? Why does this matter? It's just sort of human nature, I think.
Right. Guys, if you have questions, put it in the live chat and have your question begin with the word all caps question. So it's easy for me to find, because I actually I have some super chats that I've started, but I don't see any actual questions. So, okay. So here we go. Travis Bowman, Zach, can you explain the rules regarding objections during opening statements? Obviously quite unusual to have 16 objections. And that was just the sustained objections during the defense's opening. Yeah. What are your thoughts on this one?
So the rules as far as objections on opening statements there are none. You want to object. The only thing stopping you from objecting is your fat butt pinned in the seat. All you got to do is stand up and yell objection. There's no actual rule. And Aaron, you'll notice that every time there's an objection, the attorney stands.
No, they don't in this trial.
Oh, they don't. Okay, so it's a little more relaxed atmosphere. Of course, with 16 objections in an opening statement, you end up looking like a whack-a-mole. Yes, exactly. But opening statements are exactly that. And I don't know if you mentioned it. If you did, I don't recall. But you're not allowed to make argument in opening statement.
Right.
If you're really slick, you can weave a little bit in, and just as I start to lean forward in my chair, you get away from the argument, so I have to sit back down because now I've missed my chance. You're not allowed to make argument. You're not allowed to discuss things the court has already ruled are inadmissible. And you're not allowed to promote conjecture or other things that that the judge doesn't reasonably believe you'll be able to prove. So, for example, the defense couldn't, in their opening statement, probably say Xenu caused all this. They're going to have a hard time proving Xenu exists, right? Just like for those of us like myself, who's a Christian, we believe as people of faith that Jesus exists and did what the Bible says he does, but I can't directly prove it by bringing him into the courtroom and saying, here he is, right? So it's a little bit tough, especially in religious cases. I don't know exactly what all the objections were, the legal basis. Every objection has a legal basis. On TV, they just jump up and yell objection, and the judge says sustained. In reality, objection, hearsay, objection, improper argument, objection violates a court order, whatever. You have to stand up, or in this case, sit down, state your objection, and then give the legal basis for it. So the direct answer is there are no rules regarding objections. There are rules, however, about what an opening statement can and can't do or say. Right. And in this case, it sounds like at least 16 times the defense violated the rules pertaining to opening statement.
Nice. Hey, guys, there's 1,300 people watching and there's 500 likes. So 800 of you could go click that like button right now. I'd appreciate that. Okay, so let's see. We have Megan Rorodi. I remember how to say that name. So happy to see this. When I grow up, I want to be like you guys. Keep it up. Oh, and again, Rorodi. I knew it. Well, Megan, I'm hoping you're already grown up. Otherwise, you shouldn't be watching this channel. All right. Oh, this is funny. Is Zach from the famous Morgan & Morgan?
I'm not actually. I am familiar with the firm, but I'm not part of Morgan & Morgan. They don't have a branch in my small town of 15,000 people down here in Oklahoma. So
Morgan & Morgan for the people. Okay, Travis Bowman. Zach, can you share your thoughts on Cohen's recent interactions with Judge Almeida? It seems like he's playing with fire. He knows it, and he gives no Fs.
So, yeah, I can share my thoughts. So a couple of things. One, regardless of how scummy or slimy or otherwise unpleasant your client is, no matter how bad the things your client is accused to have done, attorneys have a legal and an ethical obligation to advocate zealously. In fact, the rules of conduct in most states and the federal courts use the term zealous. You must advocate for your client zealously. And, I'm from the South, so I mean, the common reference is NASCAR. The NASCAR drivers all want to work for the crew chief who cheats just a little bit. Right? They all want the advantage because they need to win. Right. That's their success is based on whether they win or lose. And in a race with 40 people, only one person can win. So they always want to work for the crew chief who's on the edge of getting suspended for cheating.
I like that.
Okay. And so it's the same way in the law. First off, he doesn't give an F, because if he's not going to get himself disbarred, he might get a sanction, a monetary sanction or an adverse instruction. He's also trying to build the record for appeal. I don't know Cohen. I'm sure in his private life, he's probably a stand-up guy. I have no reason to believe he's not. I would be surprised if he had, feelings one way or the other as to Masterson's guilt or innocence, but he has a job to do, and his job is to advocate for that client. And sometimes that means you got to get under the judge's skin. I've done that with judges that I respect, excuse me, highly, that I've had success in front of. And I've had judges say, Mr. Morgan, that's not, you can't do that. And I'll look at, yeah, judge, I got to try. If I get slapped down, I get slapped down. That's the nature of it. You're going to win some, you're going to lose some. So I don't inherently take issue with what Cohen does unless he's making a scene in the presence of the jury. If it's just the courtroom staff, the judge, the bailiff, the court reporter, the clerks, the lawyers, the witnesses, and then of course, the gallery full of people, put on the dog and pony show. If you misbehave in front of the jury, eventually, if you get called down enough, the jury's going to say, what is this guy doing? So it sort of depends on when he's playing with fire. Is he playing with fire in the presence of the jury, or is he playing with fire when the jury's out and he's just doing his job? So, I don't inherently take issue with it, I think.
That makes sense. Okay, Dizzy says, question, I watched a video from you earlier. You mentioned a Danny Masterson scandal that was covered up by the Celebrity Center. Can you remind me what that was, or point me to which video you mentioned it? Thanks. So what it was is when Danny Masterson got his ass beat in the middle of Sunset Boulevard by Chris Chupp. That's TSCHUPP. And I'm actually going to paste in the live chat right now the name of the video on my channel. The live chat doesn't let you post links, I don't think. So I'm just posting the name of the video on my channel. The cover up was just that Danny Masterson got beat up in the middle of Sunset Boulevard in front of the paparazzi, and the paparazzi didn't write a story about it. And that's because the Celebrity Center got a hold of him and squashed it. So that's all. Thank you for the comment, Dizzy. Let me see. Kia Moko, can the DA bring up Danny being investigated for jury tampering in trial number 1? And the answer is no, because it's a grand jury investigation and those are confidential, right?
Right. But even if he was being prosecuted, let's say that was reduced to charges through an indictment, even if he was being prosecuted in a different courtroom down the hall, still not facts for this case. They haven't been proven guilt. The facts of that case haven't been proven guilt or innocence. And so it's improper to lay that inference for the jury to draw when it's not supported by the evidence. So the answer to that's no.
Very nice. Very nice. Kim, question, why does the defense not want Leah in the courtroom? I think they just, they know that juries can be swayed by their own personal biases. It's why Danny Masterson wants celebrities sitting in his section, showing up to defend him, or, to represent and support him. It's just that Leah, I think, is a loved figure. She's seen as someone who's, stood up to Scientology and, taken some of the worst they've had to dish out. And they don't want, if they can help it, the jury to associate in their minds Leah Remini, the hero, with the victims. I mean, that's my guess. Would you agree with that?
Yeah, absolutely. And she's also very articulate. She's well-spoken. She's educated. And not everybody who speaks on behalf of Scientology can put all three of those in the same sentence as well and describe themselves in their own biography. So she's well-connected in the industry, and everybody knows who she is. So
there you go. Okay. Hold on. I got to say this. Robert Ack. Oh, AK Brenda Robert, or Alaska Brenda Robert. Okay. Is brother George Masterson attending the trial? Yes. I mistakenly identified the guy yesterday as Will Masterson. It's George Masterson who's been there for the 2 days. Do you think he believes his brother is innocent or just supports him because he's a Scientologist? I don't think they could possibly think he's innocent. I could be wrong about that. I think they're supporting him because they think because he's a Scientologist and because he's being attacked by former Scientologists. The members of his family know these women. They knew them when they were Scientologists. They knew them when Danny Masterson was in trouble for what happened with Jane Doe 1. They know these women are not making it up. So I just, yeah, it's, I don't know. I don't know what else I can say. Kendall Links, shouldn't a Scientology expert be sitting at the prosecution table to assist in clarifying questions so jurors can follow? I've sort of wondered that myself, Zach.
It depends on whether or not the rule of the rule of sequestration is invoked. A lot of times this is called invoking the rule, which means unless you are a direct party. So the Jane Does who were named as victims, Danny Masterson as the defendant. If you're a witness to the case, you can't be in the courtroom during testimony, period.
Okay, but let's say you're not a witness. I'm talking about, like, just theoretically speaking, why don't they have like Mike Rinder sitting at the table to guide them on some things? I mean, Mike's a bad example because there's a specific reason why he wouldn't be there, but theoretically.
Yeah, right. Yeah. Just, the average Joe, former Scientologist who's an expert in the operations of the church. So for all we know, there very well could be one in the gallery who's feeding information to the prosecution.
But there's not.
Okay. But also at a point, it doesn't matter anymore because the material, because again, the reason the material from the church, all the various writings and the publishings and all this other stuff is coming in isn't because Scientology's on trial.
Yeah,
it's right. If Scientology was on trial, absolutely. But in this case, Danny Masterson, a member of the church, is on trial. So the limited amount of Scientology that is coming in is being contextualized, and the DA is going to be well versed in this.
That's right. Because at this point, all that matters is the Jane Doe's answers to the questions. It's not like the expert's going to be there being like, "Oh no, she answered that question wrong," or "She nailed it." Like, who cares at that point? Once it's said, it's said.
Yeah.
Like,
and so I guess that's my, when I see the word expert as an attorney, I think witness, an expert witness, somebody who's going to be testifying as opposed to just a contextual expert. So
right. Okay. Chi-Town native question, got here late. Hi, you probably answered, but do you think Jane Doe testimony today regarding Scientology policy stuck with the jurors tonight? Oh, I think it did. I mean, so much of her testimony, maybe I want to say 30-40%, maybe 30, yeah, somewhere around there, was on the subject of Scientology. Even down to her being told that her job as his girlfriend, in order to have her exchange in properly, was to give him what he wanted when he wanted it. It's like, now it's very hard to read the jurors. I got to be honest, very hard. I thought it would be easier to read the jurors. I thought they would be more expressive. I'm not seeing a lot of nodding. I'm not seeing a lot of heads moving, whether there's, left or right or up or down. I'm not seeing any, there's no gasps. I don't know what I was expecting, but they're pretty much just stone faced.
They tend to be pretty stoic. One, that's their instruction. Two, most jurors, if they're either lucky enough or unlucky enough, depending on their personal preferences on the matter, they tend to take this very seriously. They also know that if they don't take it seriously, they're violating the law. They've taken a legal oath. They also know that the less monkeying around they do, the quicker this thing goes, they're able to move. It's kind of like playing in a golf tournament with a bunch of people. Don't let me be the reason the group behind us is waiting. Right? We're always ready to play. I don't want to be the reason this trial's delayed because I'm over here dicking around. Okay. I do want to, I may be taking this a little bit out of turn, but Downtone Abby's one of your posters. She posted a question, and I can't remember if she prefaced it with question or not. It was several pages ago. I got the chat over here as well. And she asked,
I see one. Is it 7:05 p.m.?
I maybe go and throw it on the screen. Let me look at it. Yeah, that one. Exactly. So this was a follow-up to a question that she had asked earlier, and I want to address that. There's a lot of chatter about it, which is good. I like seeing people engaging with us in the chat. But so she essentially asks, why is it going to trial if the defense is not Danny Masterson didn't do it? I think that's a fair question. The defense is it was consensual. Without a doubt, everybody agrees that the sexual contact, the sexual encounters occurred.
Right.
The question is, was it consensual or not?
That is essentially their defense is, this was consensual, or they just regretted it and now they've reframed everything. Or
sort of buyer's remorse. Yeah.
Or now they're sort of exaggerating to make it sound worse than it was, that kind of stuff.
Yeah.
Yeah. Okay. Oh, that was just the only thing you wanted to say there?
Yeah, yeah. There was
Okay.
a lot of chatter in that. I wanted to get that answered.
Got it. Got it. Okay. Jermaine Down, OSU in the house. My kiddo just submitted an application for concurrent enrollment at Oklahoma State for her high school senior year. Nice.
So I am a collegiate faculty member. I teach at the college level. I do not teach at OSU, but I am a fan of America's Brightest Orange. So
John D, thank you for the super sticker. Terry Zaleski, Zach is the best. Thanks to both of you. Keep shining the light. Well, thank you so much.
I appreciate those words. I try to help Aaron anytime I can.
Guys, we're going to be doing analysis every day this week with Zach Morgan. So stay tuned. The best is yet to come. Magic Murr, are any of the crew from that 70s show attending the trial or other actors close to him for some sort of support for him? No, the best Danny can do is to get his brothers and a child molester to show up for him. If anyone hasn't seen my video early this morning about the child molester who showed up to support Danny and who I confronted and who didn't come to court today, check out that video. His name's Graham Brewer, and he just loves molesting kids, that guy. What a rascal. Okay, Mr. Blue Sky. People who stand up to bullying are taking the high road. Thank you for standing up, Aaron. Well, thank you so much. Thank you very, very much.
And I want to throw this out there. If you're viewing this video and you have, when I say young people at home, like people who are under the age of 18 or maybe even in their late teens, early 20s, be very vigilant with them. Cyberbullying is a huge issue. I know it's a huge issue in the Church of Scientology now. It's a huge issue everywhere. Please keep very close eyes on your children. We've had some tragedies here near where I live as a result of cyberbullying. So please keep up with them. Don't be their friend, be their parent. It's completely unrelated, but that's some stuff that hit the news down here recently. So don't be their friend, be their parent.
Yeah, absolutely. Okay, two last ones just came in and then we'll wrap it up. April Joyce, hey, Aaron, this is my first ever super chat and my first live of yours that I finally caught. Hello from Australia, loving SPTV. Well, that's awesome, April. Welcome all the way in Australia. Remember, I say one of my daughters is named Brisbane after Brisbane, Australia. I love Australia. All right, and then one of my favorite names in the chat, Matrix Tech Solutions. Thank you, Matrix Tech Solutions. All right, everybody. Well, hey, if you haven't hit that like button yet, go ahead and do that.
We got one more super chat. Let's hold off on the super chats. We're gonna wrap this up, but we'll grab that last one.
All right, Rob Greenway. Aaron, do you think Tom Cruise and other celebrities in Scientology use women or men in this predatory manner? Well, here's the thing. I know that not Tom Cruise. Oh, wait, I'm sorry. Do you think Tom Cruise and other celebrities? I think Danny Masterson is an outlier in that I do believe he's an outlier. The truth is Scientologists do definitely disapprove of this type of behavior. And when you hear the things that the ethics officer and the chaplain said to Jane Doe 3, particularly, you might go, oh my God, like you can just do whatever you want. Scientology has created this framework and created this environment where the worst stuff can be excused, and very often is, especially when we're talking about abuse against children. There's so many examples of it. And yet it's still behavior that is frowned upon. I think this is a nuance that's important to explain when the opportunity arises, because look, if Scientology was a system where everyone was encouraged to just behave horribly like Danny Masterson has done, then that would mean that all of us former Scientologists were also like, oh yeah, that stuff is great. I can tell you, none of the members of SPTV will tell you that when they were in Scientology, they thought it was okay to do these things. Scientologists don't think it's okay to do these things. A lot of the stuff that you hear, the type of cover-up, is because Scientology will put its own well-being over the well-being of its members. It will put its own self-interest over the interest of its members. And it's going to tell Jane Doe 3 that it was her fault, and and she's responsible for all of this, partially to guilt her and gaslight her into not going to the authorities because now she thinks it was her fault. You see.
Yeah, and I think the word you used there that was key was cover up. This is very much the Watergate Richard Nixon thing, right? The issue isn't that the bad thing occurred. It's what happens after it occurs. Bad people exist everywhere. Bad people are in all religions. Bad people are in areas that are not religious. There are bad people who are going to do bad things. It's what happens after a bad thing is done that makes the difference. Not the doing of the bad thing, but the cover up and the lack of accountability after.
Yeah, absolutely. All right, everybody. This has been educational as always. Thank you guys for joining us. Hit that like button, guys. Hit that subscribe button. I'll be trying to do the same thing tomorrow. An update at lunch, an update after court, an analysis with Zach. And yeah, guys, that's going to kind of be the plan for the next week here. So thank you guys for watching. Thanks to everybody who watches until the very end. And we'll talk to you soon.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not, subscribe